All right, our second case this morning is 2019-939, Menorah Park Center for Senior Living versus Irene Rolston. For the appellant, Mr. Lang.
Chief Justice O'Connor, may it please the court. My name is Brian Lang and I represent the appellant Menorah Park Center for Senior Living. At this time, I'd like to reserve 3 minutes for rebuttal. Menorah Park requests that this court overrule the 8th District Court of Appeals decision, which created new law and reinstate the dismissal of the class action counterclaim of the appellee. Menorah Park's proposition of law is premised generally on the fact that HIPAA specifically provides for the disclosure of protected health information for purposes of seeking payment, whereas there is no Ohio law addressing this issue. As such, HIPAA preempts Ohio law on the issue, and further, allowing the appellee to prosecute a claimed failure to comply with the rules of HIPAA would improperly allow the enforcement of a HIPAA provision in state court, which is contrary to longstanding Ohio law. The appellant Menorah Park is currently faced with the prospect of a class action counterclaim seeking over $3 million in damages as a result of seeking to collect approximately $400 in unpaid medical bills. In order to seek payment for these services, Menorah Park filed a small claims complaint with the Shaker Heights Municipal Court, attaching to the complaint 2 account statements representing unpaid bills consistent with Civil Rule 10. The 2 account statements attached to the small claims complaint include the name and address of the appellee, the dates of service, a 2 to 3 word description of the service rendered and procedure codes, as well as the amount charged, paid, and due. The account statement.
Mr. Lang, to interrupt you, were there any aspects of the attachment redacted?
There were no aspects of the attachment that were redacted, nor does Menorah Park believe needs to be under Ohio law.
Well, could there have been any aspects redacted that could also preserve the essence of your claim?
I don't believe anything could have been redacted and provide notice of the complaint claim consistent with Civil Rule 10 and the notice provisions under Civil Rule 8. If the descriptions of the services and the dates of services were redacted and all that was there was an amount, what is the claim for? Is it for some business fee? Is it for a computer fee? Is it for a dining fee?
Well, it's interesting because if some of the private information had been redacted and then the defendant would ask for a more definite statement, then the Civil Rule 10 would still be satisfied if you then submitted the unredacted statements. It's almost then as if the defendant would be inviting error or inviting this claim if there was some redaction and then there was a request that all the information be exposed.
If that occurred with the motion for a more definite statement and then that information was disclosed, certainly the defendant would have invited that. But it's Menorah Park's position that under the minimum necessary standard in HIPAA, that Menorah Park fully complied with that standard. And that standard was not meant as an impediment to payment. It's a flexible standard. And under certain circumstances, it would have required that all of the medical records be disclosed. Certainly if this case would have been litigated and the appellee challenged down the road these services, the appellant would have to present the actual medical records establishing that these services were provided and that they should obtain payment for them. With that said, the Barberton Court in the 9th District recognized that just the amount of the payment is not sufficient to put the defendant on notice of the claims against it. With all of that said,
well, why did the procedure codes need to be on there? I mean, you could have said medical services, you could have provided dates. It seems the procedure codes are what really allows someone to know what injuries or disease this person has.
It doesn't let them know what injuries or disease the person has.
They know what you can figure it out pretty easily. You can look up the procedure codes and figure out what treatment they're getting. I mean, that's
you can figure out what treatment they're getting. With that said, Your Honor, to do that and for Ohio courts to consider that, they would be interpreting the provisions of HIPAA. Basically, they would be looking at
you're not interpreting the provisions of HIPAA to look up what the procedure codes mean. You could find. I mean, I have a hard time with your argument that somehow this is preempted by HIPAA. HIPAA just says that you can't disclose certain things for federal purposes. It doesn't prevent the state from having a more restrictive body of law about what can be disclosed. I mean, just because something is a safe harbor within HIPAA doesn't mean that it's permissible under state law.
I agree with that, Your Honor. And the point here is that HIPAA does have a specific preemption provision, and it includes an exception, as you have stated, for state laws that are more stringent than HIPAA with respect to disclosure. There is no Ohio law that specifically deals with the disclosure of protected health information for purposes of seeking payment. There's no regulation, there's no statute. The appellee has relied on the Biddle case, which certainly did not address this specific issue.
Well, isn't that kind of more the issue here? I mean, it's really not a preemption case. I mean, isn't the question whether or not we should get rid of Biddle entirely? This is an area now that's extensively regulated by the federal government. Why aren't you arguing, as some of the amicus did, that this court should? There's no longer a need for Biddle.
I certainly do agree with that, Your Honor. I think there are 2 points here. I do believe that there is preemption here because I don't believe there is an Ohio law that's more stringent than HIPAA on this issue. I don't believe there's, the Biddle case basically provides for unauthorized and unprivileged disclosures, there is a claim, but it recognizes that there are statutes, regulations, and common law that provide for disclosures. And in this instance, there's a HIPAA provision that provides for a disclosure. There's no Ohio common law that's contrary to that. But to your point regarding Biddle,
there's no HIPAA provision. The HIPAA provision, what it does is says you're not liable under HIPAA if you do these kind of disclosures. It doesn't give you a right under state law to disclose those things. In fact, HIPAA makes clear the opposite.
Well, I believe HIPAA does provide the opportunity to disclose protected health information, even under state law. I don't think there's any state law.
Well, what HIPAA says is it's not a violation of HIPAA to do that. It doesn't say it's not a violation of state law to do that. I mean, HIPAA's, absolutely clear that you can have a more restrictive requirement under state law.
I agree with that. And as the appellee relied on a number of cases, there were more restrictive means in those other cases. For instance, there were 2 cases involving ex parte communications with treating physicians, and there were specific state laws that dealt with those communications, and the courts in those cases looked at whether the state law was more stringent than HIPAA, and if it was, then the state law wasn't preempted. I don't see a state provision here dealing with disclosure of protected health information, and that there is no more stringent. With that said, going back to your original point regarding the Biddle case, I agree with Your Honor. I don't know that there is a reason for Biddle to still remain given all of the protections that are set forth in HIPAA. The HIPAA rules protect privacy and security of protected health information while affording covered entities the ability to use and disclose that information in a fair and logical system. The Biddle case doesn't get into the intricacies that HIPAA does, and obviously Biddle was decided before HIPAA. HIPAA has numerous protections for patients, including the ability to file a complaint with the Department of Health and Human Services, with patients filing over 200,000 complaints, and Health and Human Services implementing over $100 million in fines against covered entities. The penalties go up to $50,000 per instance. And in addition, HIPAA allows state attorney generals on behalf of residents of their states to obtain damages for those residents. So even under HIPAA, the patients can still obtain damages in addition to the statutory penalties that are present. And in light of those considerations, Your Honor, I agree with you. I'm not sure that Biddle should still be present. Under that Biddle test, it's very vague. It's somewhat unworkable. It talks about a countervailing interest, and because of that, all of these cases would need to be litigated and potentially resulting in disparate results, both in Ohio and across the country, in determining whether the disclosure was the minimum necessary. Certainly, and there are health systems that go across the country, and there may be one ruling in state courts that's inconsistent with a ruling in another state court. HIPAA has specific provisions that deal with all of these issues. And with the implementation of HIPAA, they specifically recognize the importance to these medical and health providers to have the ability to collect and seek payment. And that's why they allowed for the disclosure under those circumstances and set forth this minimum necessary standard. And with that, it should be left to the Department of Health and Human Services, not a state court and a jury, to determine whether that standard was met. So I agree. The question as to whether BIDL should still remain with the implementation of HIPAA, I'm not sure that it should, Your Honor. I think HIPAA does cover this area. It's very detailed. It has evolved over time with the implementation of the electronic health record, which has come into effect over the past 10 years. HIPAA has now added the HITECH Act to address that. The BIDL case doesn't address all of these intricacies. And in essence, courts would need to look at each specific issue depending on what kind of disclosure might occur to determine whether or not it would violate the BIDL standard. I think that's better left to the Department of Health and Human Services to analyze that and make the determination. The Department of Health and Human Services recognizes and is flexible, recognizes that these entities need to have the ability to seek payment and not be faced with concerns regarding potential class action counterclaims and the extensive cost of filing complaints by hiring attorneys and filing things under seal. These entities would not collect insignificant amounts such as the amount set forth herein if they were placed with the rules set forth by the appellee herein, and rather they would forego that. And that would result in an increase in the cost of medical services because that money would have to be regained somewhere. So I agree. I don't think that BIDL necessarily should still have a part. Also,
can we do that in this case, or is it properly forced? Would we need to ask for additional briefing?
No, I think you can do that in this case. I think the amici have addressed it, and I think that the question of whether BIDL applies to this case, it might be separate and apart from whether BIDL should remain, but I think the court can make that decision herein. Although it is Menorah Park's position, even if BIDL does remain, that it is preempted here. And further, to enforce this case, the court would need to consider HIPAA and the minimum necessary standard, which would be contrary to longstanding law that state courts should not consider that standard, and it's not setting forth a private right of action. And Your Honor, I'd like to reserve my remaining time for rebuttal unless you have another question.
Thank you. Mr. Flowers.
Good morning, Chief Justice O'Connor, Associate Justices. May it please the court. My name is Paul Flowers. I represent the defendant appellee in this case, Irene Rolston. After listening to counsel's argument, I'm more convinced than ever that the sole objective of this appeal is to allow debt collectors to disclose private and confidential health information in lawsuits that are publicly filed against patients who are unable to pay their bills. The simple solution is for them just to redact the descriptions of the treatment, which is what we see in the Ohio Health case that was the basis of their motion to dismiss. That court found that there was no violation, there's no BIDL claim because the information was redacted, because the disclosure was authorized, and that's all they need to do. But for reasons that are pretty clear to me now, they don't want to do that. They want that information out there in those complaints. I thought I'd start off with Justice Stewart's questions about the redaction. We see redactions all the time. Virtually every complaint for medical bills is redacts the information. They redact the codes, they redact the descriptions. They usually don't even provide the dates. They might provide the amounts paid, and that's it.
And does that satisfy Civil Rule 10?
Yes, it does, because Civil Rule 10 isn't absolute. It says that you're to provide the document unless you provide a reason in your complaint for why you're not providing it. And so,
but does Civil Rule 10 require that?
Does not. It requires the instrument to be attached unless there's an exception. And then you're supposed to state in the complaint why there's an exception, and that's routinely followed. So in fee disputes, when an attorney is suing for fees, they never attach a complete itemized billing statement. They might attach a summary, or if they do attach a billing statement, it's heavily redacted. And in commercial cases where they're about contracts that contain sensitive information, such as pricing and relationships and so forth, they either don't provide the contract, or they state in the complaint that they're not providing it because it contains sensitive information, or they'll provide a redacted copy, or they'll file it under seal. There's lots of options here.
Well, couldn't your client in this case, or defendants in similar cases, simply ask that the private information and sensitive information not needed to adjudicate the claim be redacted?
Correct. Absolutely. And they did in this case. A letter was written early on, as soon as the complaint was filed, by defense counsel saying, hey, you just disclosed all this information. And they didn't amend. They didn't change it. They left it on there. And they're fighting tooth and nail to keep it on there and to retain their right to disclose health information in these debt collection complaints.
Mr. Flowers, I think I heard counsel for Menorah say that when you have such as this, which I believe was in Shaker Heights, municipal court, that it would be too burdensome for it. I think I heard that was one of the things that was offered as a reason for that it's not practical, that it's too burdensome. And besides, they're using codes, and you'd have to go to some lengths to determine what those codes actually revealed.
Right. That's just specious. I mean, these exhibits are redacted all the time in legal cases, medical cases, all sorts of collection cases, all sorts of contract dispute cases. There's heavy redactions and explanations for why. Regularly, all it takes is a pen and a black marker and just going through it item by item. And the codes are not that hard to figure out. All you have to do is go online. The code access sheets are available. You pull them up. You can find out immediately what somebody went through. And here, this exhibit says that this woman went under a specific kind of treatment. I mean, it does not take any sort of medical knowledge to figure out from what they left on there what she went through. And maybe hers isn't so sensitive, but at Menorah Park, you're going to have people with dementia, incontinence, all sorts of medical issues that they don't want disclosed. Yet Menorah Park makes it very clear that, hey, if we need to sue you for a bill, we intend to include all this information because we've got this kind of preemption conflict issue and whatnot, and that's our right. This court should not go down that road. I mean, Biddle is no aberration. Biddle is founded on decades of law in Ohio and elsewhere. In her concurring and dissenting opinion, Justice Cook points out that Biddle is not new, that it is based on prior law. So if this court were to overturn Biddle, a lot of precedents would have to be overturned. And then Ohio would stand alone, as far as I can tell, as the only state that does not allow private remedy for disclosure of private health information. I know of no other state that has done this. There are lots of states that have Biddle-type remedies. I mean, Biddle was founded.
Yeah, Mr. Flowers,
Justice French.
Could you have had did you have the opportunity to file a HIPAA complaint?
No. If you look at Ohio Health answers that. It says that even if there was a remedy under the HIPAA, it's not the plaintiff's remedy. Only the Department of Health and Human Services or the state attorney generals can invoke it.
I guess I appreciate that. Let me be clearer. Could you have filed a request? Could you have filed something with the department that says this is a violation? Could you have notified the government of a potential violation?
Yeah, sure. And who knows where it would go. There's no guarantee of any relief. It's significant that they're not raising a failure to exhaust administrative remedies here. I mean, they've never argued that, particularly in their motion to dismiss, because there is no practical effective remedy for the patient whose information has been disclosed. Best case scenario is that, the provider who discloses this gets a fine, maybe that's it. But there's no indication that the Department of Health and Human Services and the attorney generals have the resources to monitor these tens of thousands of collection cases that are being filed across the United States and respond when private information is disclosed. I'm sure that's one of the motivating factors for Biddle, as has been adopted throughout the United States. that, these people whose privacy is violated need a remedy. It's just a basic privacy remedy situation. Nothing new. And remember, Biddle doesn't stand by itself. Biddle was affirmed in Hageman. I mean, in Chief Justice Moore's opinion, they embraced Biddle. And according to Chief Justice O'Donnell's dissent, Hageman expands on Biddle, taking it even further. So this is something that is well established in Ohio precedent. Wiping it away might be great for debt collectors, but it would take unearthing decades of case law and leaving Ohio by itself in this world as far as a remedy being provided. This whole action, the motion to dismiss, was originally based on Ohio Health versus Ryan. They're not talking about that now. I mean, Ohio Health found consistently that there is no preemption, that we had a situation where the records were redacted, which refutes this idea they can't do it. And because of that, there was a dismissal on the pleadings. And then we have the same findings in Sheldon. And the Sheldon court is very clear that there is no preemption. Despite all the arguments that were made, there's no preemption. And what the second district wrote in Sheldon is right on point with Justice DeWine's comments earlier in paragraph 25. We determined that a Biddle claim is not preempted because we failed to see how such a claim conflicts with HIPAA unless the alleged claim asserts recovery for release of information that HIPAA specifically allows.
Mr. Flower, what about Mr. Lang's statement that should this court rule in your favor, then it subjects his clients and multiple parties like them trying to recoup and recover costs for medical services, subjects them to millions of dollars in class action lawsuits?
No, I mean, that's really far-fetched. I mean, how many of these lawsuits have we seen? Everybody is redacting. They all redact. They even sometimes don't even submit billing statements. They just do a summary with the total on it.
Isn't that in violation of Civil Rule 10?
No, again, Civil Rule 10 routinely is utilized in the context of privileged and sensitive information that's in these exhibits because Civil Rule 10 allows you to state that I'm not providing it for this reason in your complaint. It's not absolute. So, I mean, if he's right about that, then all these hospitals, all these lawyers, everybody else who's redacting information is violating Civil Rule 10.
But does Civil Rule 10 require Mr. Lang or require his client to do that?
Now, again, it's not absolute. I mean, it specifically says if you put in your complaint the reason you're not providing the document,
Right, but can they? But it doesn't require them to redact.
No,
So-
the requirement to redact is in the privacy laws. I mean, just like any other complaint, bills for legal services, incidents where you've got privileged information, attorney-client privilege, perhaps, anything like that. The plaintiffs are all either redacting or not even providing the instrument entirely with an explanation of why. Now, just to follow up on your question earlier, suppose the plaintiff then files a motion for more definite statement and says, hey, you didn't include this. Well, then they've waived it. Then the plaintiff has every right to put it out there. But we don't have that here. We have the opposite, where the patient's lawyer came right out of the gate and said, hey, you're disclosing information, and they did nothing. They did nothing to try to file that under seal, to conceal it, to amend it, nothing. They are here today insisting that everything they did was right, and they can disclose what they want because the patient won't pay their bill. And that's just not a road that this court should go down. It's completely contrary to Ohio precedent and precedent across the country.
So I wonder if we could go back to Ohio Health and your reading of Ohio Health. As I look at Ohio Health, it seems to me what the court was saying was, the question is whether there was an unauthorized disclosure. And you look at other sources to decide, is this unauthorized? And one of the sources that you look to is HIPAA. And because HIPAA specifically authorizes the use of medical information for purposes of collection, this is not an unauthorized disclosure. So I think, are we reading Ohio Health differently? That seems to me to work in Mr. Lang's favor here. If the question is it unauthorized, and we say no, it's not under HIPAA, does that end the matter?
But I was in full agreement with you right up to that last part about supporting
I
Mr.
thought
Lang.
you would be, so tell me why.
I mean, I think Ohio Health, like Sheldon, fully supports our position because, in Ohio Health, the issue is it authorized? And, if it is under any law, not just HIPAA, if it's authorized under any law, paragraph 2 of the syllabus of Biddle says there's no claim, so there's never any preemption because there's never any conflict. Biddle excludes that. And just to point out, I'm getting your answer in a minute, to point out, the HIPAA was enacted in 1996. Biddle came out in 1999. So HIPAA was there first. The current regulations, sure, they came afterwards, but the Biddle court, I'm sure, was well aware of HIPAA at the time this was enacted, and the Hageman court certainly was aware of HIPAA because they cited it. Just to get back to your question, yeah, that's the nub of it. That's what this case is about. If it's authorized, they win. If it's not authorized, we lose. And it's spelled out in their reply brief, which I fully agree with. This is on page 10. If a jury determines Menorah Park took reasonable efforts to limit disclosure to minimum necessary within the meaning of CFR 164.502B, then the disclosure would have been authorized by federal regulations and any contrary state common law claim would be preempted. Moreover, if disclosure is found to have been authorized, then it would not have been unauthorized disclosure required under Ohio common law in Biddle. That's exactly right. I mean, that's the nub of it. And you can't decide that in a 12B6 motion. Whether they did the minimum necessary as the regulations require is an issue that has to be determined in this case. And they're not going to win that because they did nothing.
Right, but aren't we right back to preemption then? If
Now,
what we're really talking about is compliance with HIPAA, why isn't that a HIPAA question and it's preempted?
It's not preemption because it's the cart before the horse. I mean, Biddle says if you comply with any law, that's privileged. That's paragraph 2 of Biddle. So HIPAA, any state law, anything, if they can show that they're complying with that, then there's no Biddle claim. It's a defense. So you don't get any preemption. And that's what the Sheldon court said is, we don't see how this conflicts, because you're never going to interfere with HIPAA because HIPAA is a defense. Just like any other state law that permits disclosure, and there's a lot of them, are defenses as well. So that is why there is no court that has held that these types of Biddle claims are preempted by federal law. In fact, the 8th District in their decision, they cite a laundry list of out-of-state cases all holding that there's no preemption, and there's no serious argument with any of them. I mean, this court is being urged to break new ground in this country for the sole purpose of just allowing confidential health information to be disclosed in complaints that are filed against patients. So I see my time is winding down. With that, I would thank everyone and ask you to affirm the 8th District Court of Appeals.
Thank you. Mr. Lang, you have a little over 2 minutes. You have to turn your microphone on to use them.
I apologize, Your Honor. Thank you. First, I would like to address the Ohio Health decision because I don't understand Mr. Flowers' representation of this case. In paragraph 17 of Ohio Health, it specifically states, here, however, we are aware of no applicable exceptions to preemption, and because HIPAA is applicable to these circumstances, HIPAA is the governing authority. Therefore, because appellant has failed to cite to any Ohio authority which is contrary to HIPAA regarding the disclosure of protected health information for purposes of payment for medical services, and which meets an exception to the federal regulation, appellant's claim is governed by HIPAA. Ohio Health stands for the proposition that HIPAA preempts state law with respect to this specific issue. It's not Menorah Park's argument that HIPAA preempts all potential causes of action for disclosure of protected health information. But in these,
Mr. Flowers says that his client requested that the complaint be refiled and the information be redacted. What was the problem with complying with that request?
Your Honor, I'm not aware of that. That's not part of the record, and I was not representing Menorah Park at the time the small claims complaint was filed. With that said, getting back, also addressing the ICD-9 codes, those codes aren't protected health information. It simply reflects the services that were provided to the individual. I'll also address the Sheldon case, which
Counsel, let's talk about those codes. They're pretty telling, are they not? if you have the key to review those codes, you know what the health issues are.
You don't know what the health issues are. You know what services were provided. At the same time, if we attach an account statement that only includes the amount of money that is owed, the plaintiff is put on no notice of the services that were provided for which payment is being sought. But Menorah Park was simply
But that information could have been submitted under seal, correct?
Your Honor, it could have been submitted under seal, but if medical institutions are required to submit documents under seal and file claims with attorneys for these small amounts of money, $400, $500, $1,000, they're just not going to do it. They're going to forego the ability.
I don't know that I can accept that this is not economically feasible for the plaintiff here in the collection actions. So we can violate, the private information, health information. I don't know that that's a justification here.
Well, the supposed violation here is a violation of HIPAA, Your Honor. It's the minimum necessary standard, which, as recognized by Ohio Health, should be enforced by the Department of Health and Human Services. If, in fact, there's a violation here, I believe that a question was asked earlier. Certainly, there's the opportunity to file a complaint with Health and Human Services. Certainly, there's the opportunity to contact your Attorney General and ask them to pursue a complaint on your behalf in which you can actually receive damages. But the point remains, there is no more stringent law in Ohio with respect to the minimum necessary standards set forth in HIPAA for purposes of disclosure for payment. And because there's no more stringent law, HIPAA governs. And to allow the appellee to proceed in a case and basically have a trier of fact determine this minimum necessary standard would be contrary to the law, which says you can't enforce HIPAA in the state action.
Thank you.
Your Honor,
Counsel.
thank you.
Take the matter under advisement. You'll be notified of our decision.